by Michael H.Roffer. I came across this book in the library, and let me tell you, it is so interesting. It is fascinating in the sense that it has 250 milestones in the history of law, from Hammurabi to the International Criminal Court. And the illustrations at the side of each one is, it's a must read, or you have to have this book to see how good it is. Michael H.Roffer, Associate Librarian for Reader Services and Professor of Legal Research at New York Law School. He earned his JD Magna Cum Laude from New York Law School and his Master's in Library and Information Science from Rutgers University. A member of the New York Bar since 1984, he served as a law clerk for Senior Judge Roger J. Minor of the U.S. Court of Appeals for the Second Circuit and practiced law at a major New York City law firm before joining New York Law School in 2003. His articles on antitrust, criminal procedure, and employment law have appeared in academic and professional law journals, and he has lectured at continuing legal education programs for attorneys and lectures at continuing professional education program for law librarians. He lives in New York City with his wife and 2 children. Well, I'm reading from the inside cover. So, a great librarian. It's written, Michael H.Roffer is Associate Librarian for Reader Services and Professor of Legal Research at New York Law School when the book was released. So in this book, there are 250 of the most intriguing milestones in the history of law, and I'm going to read the contents to let you know what they are. So dating back to BC, the oldest written will, then the oldest Namu, then the Code of Hammurabi, the 10 Commandments, the Draconian Code, the Law of Solon, the Gotten Code, the 12 Tablets, the Trial of Socrates, the Talmud, the First Law School, the Brehon Laws of Ireland, the Justinian Code, the Irish Copyright War, the Tang Code, the Quran, Canon Law, and the Decretum Gratiani, the Asses of Shalantin, Lex Mercatoria, the Magna Carta, the Statutes of Westminster, the Star Chamber, the Trial of Joan of Arc, Littleton's Tenures, the Alhambra Decree, Les Termes de la Ley, an Act for the Relief of the Poor, compulsory education laws, on the law of war and peace, you have, and then you have, you can read 1629, the first Blue Laws, 1648 Peace of Westphalia, the Leviathan, Bushell's Case, the Habeas Corpus Act of 1679, the Black Code of Louis XIV, the Salem Witchcraft Trials, Lapse of the Licensing Act, the Statute of Anne, the Bubble Act, the Trial of John Peter Zenger, the Gin Act of 1751, the Writs of Assistance Case, Blackstone's Commentaries, the U.S. Constitution, the Judiciary Act of 1789, the Declaration of the Rights, the Americans' First Copyright Law, the Bill of Rights, the Coinage Act of 1792, the Triple Assessment, the Power of Judicial Review, the Napoleonic the Napoleonic Code, the superiority of possession, the supremacy of the federal law, the supremacy of federal courts, congressional regulation, hamstring native peoples, the Amistad, recognition of labor unions, the M. Nagatam Rule. I've turned the page to show 1848, the Field Code, then the measure of contract damages, the Dred Scott decision, the Government Printing Office, the Emancipation Proclamation, the Geneva Convention, the abolition of slavery, the Civil Rights of 1866, impeaching President Andrew Johnson, the 14th Amendment, prohibition of racial voter discrimination, the Law School Revolution, law reporting and legal publishing, obscenity and the Comstock Act, admission of women to the bar, that was in 1873, legal aid societies, the Berne Convention, the Insanity Defense, the Chinese Exclusion Act, the Civil Rights Cases, Equal Protection Rights, the Interstate Commerce Act, the Brazilian Slave Emancipation Act, the Right to Privacy, the Sherman Antitrust Act, New Zealand Women's Suffrage, that was in 1893. Then you have Plessy versus Ferguson, separate but equal. Then corporate personhood and liability, the German Civil Code, the Cuban Constitution of 1901, women in factories, 1908. Then you have congressional power to tax income in 1910, the White Slave Traffic Act, then 1910 again, Workers' Compensation Law. 1911 we have the busting of truths, the Triangle Shirtwaist Fire, the Federal Reserve Act, the Exclusionary Rule, the Clayton Antitrust Act, the prohibition of illegal narcotics, the Child Labor Act of 1916, the expansion of consumer rights in 1916, prohibition, women's right to vote, 1919, yelling fire in a crowded theater. Then New York State legalizes boxing in 1920, the Chicago Black Sox trial, censorship and the Hayes Office, the Emergency Quota Act, the Scopes Monkey Trial, the United States Code, the Danger Zone in Trot Law in 1928. Then we have wiretaps, Hitler's Rise to Power, 1933, Wall Street Regulation, Censorship and Ulysses, the Repeal of Prohibition, 1933, the Federal Communication Act, the Securities Exchange Act, the National Labor Regulation Act, the Nuremberg Laws, the Social Security Act, the Federal Register, the FDR and Court Packing Plan, Cameras in the Courts, 1937, Rule 23 and Modern Class Action, the Food, Drug and Cosmetic Act, that was in 1938, the Fair Labor Standards Act, 1938. So 1939, you have Voters and the Right to Bear Arms, 1940, the Alien Registration Act, Strict Products Liability, California's Anti-OK Statute, Interment of Japanese Americans, the GI Bill, the Nuremberg Trials, Rent Control in 1946, the Protection of Trademarks, 1946, Colonialism and Post-War Independence, General Agreement on Tariffs and Trade, 1948, the UN Convention on Genocide, the Hollywood 10, 1948, the Universal Declaration of Human Rights, 1948, the Displaced Person Act, 1948, rejection of the Alien Registration Act, the Rosenberg Trial, the EU and the Treaty of Paris, Brown versus Board of Education, the Communist Control Act, the Interstate Highway Act, 1956, the Limits on Obscenity, 1957, the Wolfenden Report and Gay Rights, 1957, the European Court of Human Rights, 1959. Again, there was No Man's Land, States and the Exclusionary Rule, 1961, the Eichmann Trial, 1961, the Trial of Nelson Mandela, 1963, the Right to Counsel in State Court, 1963, the Limits on Libel Laws, 1964, the Civil Rights Act of 1964, the Voting Rights Act, the Conscientious Objection, the Body and the Rights and the Right of Privacy, 1965, the Freedom of Information Act. Then you have the Miranda Warnings, 1967, interracial marriage, 1967, the Vietnam era draft laws, no faith divorce, free speech and threats of violence, the Fairness Doctrines, the National Environmental Policy Act of 1970, the Court Martial of William Calley Jr., Public Health and Cigarettes, 1970, the RICO Act, and the Baseball's Reserve Clause, the Occupational Safety and Health Act, 1970, the trial of Charles Manson, enfranchising 18-year-olds, 1971, the Pentagon Papers, 1971, employment discrimination, court-ordered school busing, banning the death penalty, 1972, the Equal Employment Opportunity Act, 1972, the Equal Rights Amendment, the trial of broken treaties, the Endangered Species Act, 1973, the first ban on gay marriage, 1973, a new obscenity standard, 1973, Roe versus Wade, the War Powers Act of 1973, presidential subpoena compliance, attorneys' fee awards, restrictions on involuntary commitment, racism and UN resolution, 1975, the right to die in 1976, health care and the duty to warn, 1976, the Copyright Act of 1976, 1976, the death penalty returns, alimony, attorney advertising, affirmative action, the FCC and filthy words, the son of Sam Law, the entrapment defense, the McMartin molestation case, first mandatory seat belt law, 1984, administrative agency determinations, parody and the First Amendment, time shifting and fair use, 1984, preemptory challenges to jury selection, the first evidentiary use of DNA, that was in 1986, 1987, pregnancy discrimination, Robert Bork's Supreme Court nomination, surrogate motherhood in 1988, women's admission to private clubs in 1988, the fatwa against the Satanic Verses, 1989, celebrity tax prosecution, the first gay marriage laws in 1989, the Americans and the Disabilities Act, the end of apartheid in 1990, confirming Clarence Thomas, the trial of Manuel Noriega, 1992 smoking litigation, 1992 the Rio Conference, creation of European Union in 1993, the hot coffee case, 1994, stem cell and cloning legislation in 1995, the O.J. Simpson murder trial, limits of punitive damages, South Africa's constitution, 1996, legalization of marijuana, 1996, presidential immunity. 1997, he's given the Communications Decency Act. Then the physician assisted suicide, that was in 1997. The line item veto, indictment of Augusto Pinochet, copyright in the digital age in 1999, Bush versus Gore. Then the Microsoft monopoly, 2000, golf carts on the PGA Tour, 2001, expanded copyrights, 2001, the USA Patriot Act, the Sarbanes-Oxley Act, the International Criminal Court, public purpose and eminent domain, the legality of gun control, 2008, Google Books and fair use, and Wall Street Reform, 2010, the future of juvenile punishment, 2012, the Affordable Care Act, the legal fight for gay marriage, 2015. So these are the acts that he's given in so many years. 2015 he stops. Acknowledgement is given on 510 page, notes and further reading, images, credits he's given to so many people, and the index. Really, one should have this in one's library. And I read from the introduction, the law surrounds us. So Michael H.Roffer writes in his introduction, the law surrounds us. It affects the food we eat, the water we drink, and the air we breathe. It travels with us. It defines our relationships with the people with whom we live, work, and share space. It affects our homes and schools, our offices and stores. The law touches every aspect of our lives and even our deaths. This book explains how much of that came to pass. Historians trace the first formal compilation of laws to the king or Namo of Sumer, circa 2100 BC. Several centuries thereafter came King Hammurabi's better-known code, famous for its retributive eye for an eye. So eye for an eye he talked about later. Notable laws include the 10 Commandments, the Law of Solon, the 12 Tables of Roman Law, and the Justinian Code. English laws existed prior to the Norman conquest in 1066, but their development in the context of modern law began with the Magna Carta in 1215 and its implementation through the Statutes of Westminster 1 and 2 in 1275 and 1285. Anglo-American law began to take shape in the American colonies in the early 1600s, which laid the foundation for the Constitution in 1785. Over the centuries that followed, American law took root. As it developed and matured, two competing principles emerged: stability and change. The law provides stability in a changing world, and a world in flux changes the law to maintain stability. A hallmark of the American tradition, precedents typically serve as the basis for judicial decisions. As Supreme Court Justice Benjamin Cardozo observed, what has once been settled by precedent will not be unsettled overnight. For certainty and uniformity are gains not likely to be sacrificed, yet the law does change. Slavery was permitted and then outlawed. The death penalty was barred and then reinstated. Books were banned and then constitutionally protected. Dramatic changes like these sometimes may seem inconsistent, but they embody legal scholar Roscoe Pound's aphorism that the law must be stable and yet it cannot stand still. I've taken he writes, Michael H. H.Roffer, I've taken an eclectic approach in compiling the 250 milestones in this book. As you will see, my choices fall predominantly within the American tradition, and the majority of the essays focus on the last 2 centuries, which intentionally reflects the law's steady expansion over time and more recent explosive growth. Some essays embody key court decisions, while others examine important statutes. Many deal with events that have become a part of history, including infamous trials, and several speaks to key texts that have shaped legal thought and theory. He writes, foundational texts, including the Assizes of Clarendon and the Magna Carta, laid the historical groundwork for many of the procedural protections that safeguard against overzealous enforcement of laws and the encouragements of political power in the courtroom, or they proscribe various forms of discrimination. Slavery legislation evolved from a codification of practices in the Black Code of Louis XIV to worldwide abolition 2 centuries later. Women began their long legal struggle for recognition and fairness, first in Illinois bar in the early 1870s, then in factories, at the voting booth, and in the courtroom, where they defended their rights to bodily privacy and staved off social discrimination. The concept of a right to privacy originated in an 1819 Law Review article, evolving to encompass regulation of access to contraception and birth control, and play a key role in the long-fought battle over gay marriage. Now, copyright law emerged to protect the rights of authors and other creators, and later defined the nature and limits of fair use. Laws regulating the nature of expression developed to permit seditious speech, to block words that incite danger, and to allow obscenity and indecency, but also to allow the government to regulate the public exposure to obscenity and indecency. In the realm of workplace, labor unions gained legal recognition in 1872, but it took nearly a century for employees and unions to level the playing field with employers through collective bargaining. Congress also enacted legislation providing fair treatment and fair pay for workers, along with additional workplace protection. In the overlapping sphere of finance, the law has played an important role in regulating money. Britain adopted history's first income tax statute in 1799, but not until 1913 did America's first permanent income tax hit the books. A decade and a half later, Wall Street crashed, triggering the Great Depression and a raft of regulations that Congress bolstered and amplified some 75 years later, when the collapse of the subprime mortgage market prompted the Great Recession. Many of the other milestones reflect laws aimed at protecting individuals from the conduct of others, but sometimes they aim to protect people from themselves. Blue laws existed in antiquity, but more recent legislation targeted gin, opium, alcohol in general, and tobacco. Many laws spurred infamous trials, including the Salem witchcraft trials and the communist witch hunt that led to the HUAC hearings of the Hollywood 10 and the O.J. Simpson trial, which officially heralded the age of courtroom television. Michael further writes in his introduction, the law is all-inclusive and far-ranging. As such, I've tried to capture the breadth and a representative sampling of important topics with broad appeal. But these 250 milestones cannot be taken as the 250 landmarks of legal history. Reasonable minds will disagree on the importance of specific legal events and developments and their role in the pantheon of legal history, and milestones resonate differently in various places. But of these milestones, most have effected profound change, for good or for bad, and each reflects a new historical structure or path on the legal landscape. My goal wasn't just to introduce some of the most meaningful and influential steps in legal history, but also to explain why a particular step became a milestone. Some will be obvious, others more subtle. I also aim to supply a basic understanding of what have become fundamental legal principles and ultimately connect the dots between the principles and their relevant landmarks. These encounters all will be brief and none comprehensive. Indeed, most barely scratch the surface of issues to which judges and scholars have devoted and continue to devote a great deal of thought, energy, and writing. But hopefully the essays and their accompanying imagery will pique your curiosity and entice you to delve deeper into areas you find relevant or compelling. And I so agree when he writes that I'm going to reread this, what he says, what Michael H.Roffer writes in his introduction. But hopefully the essays that he's written here, the 250 essays, and their accompanying imagery will pique your curiosity and entice you to delve deeper into areas you find relevant or compelling. Very well said. Organizationally, the essays appear in chronological order, and given the interrelated nature of many legal principles, you will find helpful cross-references throughout. Although each essay is ascribed to a single year, many of the legal developments or events in this book fall within a range of possible dates. Dates for legislation all refer to date of enactment, which isn't necessarily the law's effective date. A final and unnecessary caveat: none of these entries contains or offers legal advice. Really so well, what a well-written, well-crafted book. Let me read the ISBN number 978-1-4549-0168-6. Worth the read. Worth having it in your library, rather, everyone. Lawyers or non-lawyers, all. A ready reckoner indeed. What an interesting book by Michael H.